to the fifth case on this morning's docket. That is case number 112469, Tracy Ullery v. Windsor Place, LLC.
And may it please the court, this is Linus Baker, appearing on behalf of the appellants Tracy and Christopher Ullery. I'd like to reserve 3 minutes of rebuttal time.
3 minutes is granted, and as I have requested of other counsel this morning, if you could spend maybe 60 seconds laying out some facts so our audience knows why we're here.
All right. This is a wrongful death case in which Jamie Ullery, a disabled woman, was killed in a car accident. And I represent the estate of Jamie and her son. And the facts of this case center in on a trip that her two caregivers, which happened to be her mother, Joanne O'Brien, and Alice Beatty. And there was a company called Windsor Place that helped these disabled people pay for caregivers. And on this particular day, Windsor Place had set up training for these caregivers to go and learn about how to dial in their telephone hours. And they said, if you don't come to this training, you're not going to get paid. Well, they went, Joanne and Alice, and they took Jamie. So they go to the training. On the way back, they stop at a McDonald's, and it just so happened that Joanne's granddaughter's husband was there and saw Joanne and said, "You look terrible. Let me drive you home. You're just bad." And she said, "No, I think I can make it." Well, on the way back, she falls asleep or blacks out. Another car driven by Darren Othick, he sees the car, and instead of pulling off, he pulls over into her lane, and he speeds up. Well, she wakes up, realizes she's in the wrong lane. Now she gets in the right lane. Now they're in the wrong lane, and they have a collision head-on in the middle of the highway. Jamie dies 18 days later. So we filed a suit against Darren Othick, Joanne O'Brien, Alice Beatty, and Windsor Place, saying that Windsor Place was vicariously liable as the employer, is the one who said you people have to go to this training, and against Alice Beatty because she should have warned Jamie, and for Joanne O'Brien for negligent driving, and for Mr. Othick for his negligence. The district court made summary judgment ruling in favor of Windsor Place and Alice Beatty, saying there was no connection, or he couldn't find a connection sufficient to hold either one liable. The court then, I filed a motion to certify that those two individuals, those judgments, as final. And Judge Fairchild in Douglas County agreed, and he certified it as final. The Court of Appeals, so we filed a timely notice of appeal. The Court of Appeals issued a show cause order saying that they didn't have jurisdiction over the appeal. And so saying that they had a case and prime lending, in which they said the only time that a district court can certify any judgment as final is sua sponte, and that they had to do it at the moment when they enter the judgment. Well, and so the court then dismissed or said they didn't have jurisdiction. This court now has taken it up on the petition for review.
And underlying all of this is that we require that the judgment in the case be final before it's appealed, in order that every little adverse ruling is not taken on appeal. We don't have piecemeal.
That's okay? Right. So that is the policy, so that when you all or whoever does that, they have the whole case, and that way you can decide all the issues. But
And as a practical matter here, what we're really talking about is whether you get to appeal the dismissal of two of the defendants now, or whether you have to wait till the entire case is over and include that issue with any other complaints you have.
And yes, that is the issue. And the reason that you have a KSA 6254, which gives a district court the power to certify certain things as final, is to prevent two trials. Because in this case, had we gone to trial, this is what we call comparative fault. So every defendant gets to point at each other and say, you're a percentage of fault. Well, if we knock out two of them and we eliminate that and we go to trial just with Miss O'Brien and Darren Othick, and then on appeal, we come back and say, well, the district court made a mistake, bring back Windsor Place, bring back Alice Beatty, we have to do it over again. So it avoids two trials. The court dealt with this case, nearly identical, the Martell Driscoll case. It was a wrongful death case. It came after prime lending. In that case, just like in the case, the judge there dismissed out a fellow, Leroy, on a theory that he didn't negligently entrust a vehicle. The court later certified that dismissal as final. Luckily for them, you all took it up on a transfer, because had it been left to the Court of Appeals, they would have kicked it out. So this court took it, had no problem with the later certification, and it saved two trials because the court reversed that dismissal of that individual. So in this case, I don't know that I've cited what the court's own rules talk about in the docketing statement, the notion of when there is a judgment, and then if there is an order certifying it, and what date that is. Well, under prime lending's interpretation, that could never be possible, because the certification has to occur simultaneously with the underlying judgment. What it creates is something that I cite in my petition, which federal judge, our rules are patterned after that, says that the judges shouldn't sua sponte certify as final. They ought to let the parties flesh that out and inform the court about that. So the very procedure that prime lending requires is something that federal courts say you shouldn't really do anyway. So I think the only real argument, the substance of the argument here, is not that prime lending doesn't correctly interpret 6254. I think the argument's going to be that by certifying the appeal now, that somehow that's so intertwined that there may be some repetition of those issues. And to that argument, there's not going to be any repetition of the issues that the Court of Appeal will deal with. The theories against Alice Beatty and Windsor Place are based entirely on different theories than the drivers. They had we say they had a special relationship, an employer relationship, something that stands apart. And so the Court of Appeals, when in dealing with that, they'll never have to come back to that issue again. Once they decide that, then the court can say thumbs up or thumbs down, but then we go back to the trial, we have that litigation, we'll never come back to have to deal with that again. So,
Counsel?
Yes.
I'm not sure it's going to matter because this is jurisdiction based, but just out of curiosity, I couldn't remember, did the defense object to your motion to certify the judgment as final?
I think I had one or two, maybe they can help correct, but they did not, which for me is kind of reverse world, because the defendants here are purposely wanting to subject themselves to 2 trials, which they should have said, we just want one, let's get this figured out now. But they did raise that.
So there was an objection?
Yes,
Okay.
yes. Some did, some didn't. Windsor Place didn't object. I don't believe so. So I think this is a real straightforward case. And so having said that, I'll wait to, unless there's any questions.
Any more questions? Thank you, counsel.
Good morning. Samuel Green. I'm here on behalf of Alice Beatty, who was a defendant below. Counsel for Defendant O'Brien would also like to present some arguments, so I'll take the first 10 minutes and he'll take the last 5 if that's okay.
That's agreeable, thank you.
Counsel, can we assume that you're going to argue the issues raised in your supplemental brief?
That is correct.
Why are they before us on the petition for review?
Because this is an issue of jurisdiction that the Court of Appeals dismissed the appeal on jurisdictional grounds, and
Your issues have to do with the merits, don't they?
they do not.
Explain that to me. Not the merits of the case, not the underlying personal injury or wrongful death suit, but the merits of deciding the motion, don't they? They have to do with the merits of deciding the motion to certify, correct?
That is correct, yes.
They don't have to do with whether that motion could be entertained at a later time, whether
Other
it could
than-
be granted months after the fact of the summary judgment's being granted. They don't have to do with any of that, do they?
Not directly, other than incorporating the other supplemental brief, correct.
Okay, thank you.
The jurisdiction is from a final judgment. Here, what was certified as final under 60-254B. This court's decisions make clear that even on appeal, that certification has to be examined. A district court cannot just grant a certification or a motion to certify and create a final judgment when the judgment is in fact not final. And just a couple points that illustrate how the underlying judgment is not final here. The district court has stayed all proceedings, is my understanding, and there are no proceedings going on below. The district judge doesn't even think that he should proceed until this appeal has been decided. I mean, I don't think that he believes that this is a final judgment. The second point is that the memorandum decision was a 60-plus page memorandum decision granting various motions or denying various motions for summary judgment by various parties. One of those issues was Defendant O'Brien had raised on summary judgment a lack of evidence of conscious pain and suffering to continue with a survivor claim. The judge denied that motion, saying there was sufficient evidence to overcome summary judgment. Well, that has now been certified as final. The claim has never been presented to a trier of fact yet. It's not been presented to a jury. I mean, a denial of summary judgment is not a final judgment. So even inherent within this the memorandum decision and the certification is an inconsistency, an obvious lack of finality. I agree with counsel that the issues are straightforward. This is a matter of jurisdiction. There are numerous cases from this court applying the same standards that federal courts apply, that the U.S. Supreme Court first cited in Curtis Wright, that the district court is to act as a gatekeeper, a dispatcher, quote-unquote dispatcher, in examining these issues, and should not just routinely grant a certification. And the interests of justice, judicial administration, whether the claims are in fact separate or not, all of these issues should be examined and considered. And in this case, they were not. This is a comparative fault case. It is numerous defendants alleged to have caused a single accident or contributed to a single set of injuries and the resulting death of Ms. Eulery.
Counsel, just
Yes.
so I make sure, obviously the record isn't very developed here for us, so it makes it a little more difficult for all of us. But these 2 summary judgments were granted completely as to those parties, correct? That let them out of the case entirely. They didn't have any, you don't have any remaining, there are no remaining claims on the part of the plaintiff against these two defendants, Beatty and...
Correct. Although Ms. Beatty is still in the case as a cross-claim plaintiff.
Okay.
Correct. She was in the car with the driver, defendant O'Brien, also.
But as a defendant, she's out.
Correct.
And do you disagree with opposing counsel that if those summary judgments are deemed to be incorrect, that will necessitate another trial where comparative fault is assigned against all defendants instead of just the remaining defendants?
In this case, no, because all proceedings have been stayed. So there has been no trial. If the case had proceeded below, then yes, the case on the merits would probably be to the Court of Appeals by now, would be my assumption. I mean, the summary judgment was granted in February of 2014. We're nearly 2 years beyond that. So if the trial had proceeded and it was later determined that the summary judgment in favor of Beatty was incorrect, yes, that there would have had to have been a subsequent trial.
But the point is, if these two defendants lose on appeal, 2 trials have been avoided. If they are allowed, the certification is allowed to proceed, correct?
That is correct.
Okay.
In this case, that is correct. But that is the precise policy that the legislation or the statutes try to prohibit, these piecemeal appeals. And that is what this is. This is an interlocutory appeal from certain orders that have been entered, and all of those orders have been certified as final.
But the reason that we allow piecemeal is if it will avoid piecemeal trials.
And there are...
Correct?
That is correct, yes.
And that's why the Court of Appeals requires that not only the district court certify the judgment is final, but then the Court of Appeals has discretion to determine whether judicial economy warrants taking that interlocutory appeal or denying that request, correct?
Correct. That is a key distinction, I think, from this matter. In the interlocutory appeal context, the statute is clear that the very order that's going to be appealed from has to contain the requisite findings. And that statute is clear, and it says that. And that appeal has to be brought within 14 days, or the motion to bring the appeal. And it gives both the district court and the Court of Appeals the discretion to take it. If this was allowed to proceed as it has got to this point, it has removed the discretion from the Court of Appeals to whether the issues are controlling. All the Court of Appeals is looking at is jurisdiction, whether this is in fact final or not. In the interlocutory appeal context, there are specific, a controlling issue of law that might help the entire case. It is not just random orders and random findings of the district judge. Briefly, the Martel case, the issue of jurisdiction was not before the court. I don't think that case applies at all. So I believe the Court of Appeals was correct in dismissing this case for lack of jurisdiction. Whether it's under prime limiting or otherwise, the judgment below is not final. If there are no further questions, I will give way to
Are you prepared to
counsel.
talk about the Deaver case?
The which case?
The Deaver case. It's a newer Court of Appeals case. Are you familiar with that case?
I am not.
Okay.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, my name is Tyler Hibbler. I represent Joanne O'Brien in this litigation. And perhaps more so than any other party in this case, my client has an interest in seeing this case move forward to resolution. My client is an elderly individual who is being prosecuted for the wrongful death of her daughter, who is being sued by her grandson. She desperately wants to see this matter pushed in the rearview mirror and have it put behind her. As a result of this piecemeal appeal, my client has missed out on her original trial date. My client is now subject to the appellate yo-yo, where this court will determine whether or not the merits of summary judgment rulings concerning non-parties will be addressed by the Court of Appeals, which will inherently, if allowed, result in further delay. At that stage, if the appeal is allowed to go forward, the case will inherently be sent back down to the district court for trial. My client then stands to see a further delay of being set on the trial court's calendar. All in all, by the time this case is resolved, if this road is allowed to progress, if the plaintiff is allowed to carry on the path that he wants to take, my client stands to see this case finally being resolved upwards of 10 years after it was originally filed. That is not consistent with KSA 6102, which demands the speedy, just, and inexpensive determination of every matter pending before our civil courts. I'll circle back and address a couple of the cases that have been talked about today. The Martel case, I agree with my co-counsel's representations that it is not applicable to this circumstance. Jurisdiction was not addressed within that case. Additionally, the Prime Lending 2 case focuses upon a court's ability to retroactively certify a judgment which did not include the necessary language. The initial judgment, the order, did not include the necessary language representing that there was no just reason for delay. In Martel, there's no indication, one way or the other, as to whether or not that initial order possessed that necessary language, those magic words of no just reason for delay. Based upon that, I do believe that Prime Lending is the controlling case that's currently before the court, and I believe that the Court of Appeals appropriately and properly denied jurisdiction.
Are you familiar with Deaver, counsel?
Unfortunately, I am not. I apologize for that.
It's a more recent Court of Appeals.
We'll be happy to submit supplemental briefs if the court wishes us to on that case. However, I do believe that Prime Lending is extremely applicable because if you look at the factual scenario in Prime Lending 2, the court did not indicate in the initial ruling that there was no reason for just delay. Several months have passed. In this instance, summary judgment was granted in February. It was certified as final, I believe, in July. That initial order did not contain a representation that there was no just reason for delay. And in fact, the timeline suggests that the court didn't even necessarily believe that because multiple months had expired and went past before this was certified as a final judgment. And in fact, we were on the eve of trial. The parties had submitted their pretrial questionnaires and were preparing to try this matter when it was certified as final and stayed the case.
Did anyone argue that the district court did not have the authority to retroactively finalize the journal entry as opposed to arguing just the merits that you shouldn't finalize?
I believe that argument may have been raised by Ms. Beatty's counsel during the initial hearing. I apologize, I don't have those briefs directly in front of me and can't make a representation certainly one way or the other.
Can you refresh my recollection whether the district judge sua sponte stayed the lower court proceedings or if that was done at the request of a party or counsel?
I believe that was done sua sponte by the court. Now, again, this was obviously 2 years ago that this hearing was conducted, and without having a transcript of the hearing directly in front of me, I'm really not comfortable speaking on behalf of Judge Fairchild in the district court in that regard. However, I do know that is typically the policy that is invoked by the courts in these situations where the case is stayed. And inherently, it would have been inconsistent with what the court was attempting to do here if it had not stayed the underlying action, because it would not have avoided the potential for 2 trials. Now, addressing the concern for 2 trials, that's assuming that plaintiff is successful on his underlying appeal, that we would have potentially 2 trials. If this case would have been allowed to go forward to trial, first and foremost, it would be before the Court of Appeals on the substantive issues as of this date already. But if the court allowed it to go forward and there was a trial, my client obtained a final judgment, resolution of the matter, one way or the other, and then an appeal was taken up. if the plaintiff succeeded, yes, I do concede that that would possibly result in a subsequent trial.
But isn't that part of the district court's calculus when it gets a motion to certify an interlocutory issue is, that this is an important question that reasonable minds might differ, and so we're going to certify. I mean, it is not an automatic act for the district court to let this thing go up to the Court of Appeals.
I agree with that, Justice Biles. In fact, the case law overwhelmingly states that district courts should hesitate to utilize 6254B as a result of its potential impact upon the litigants. And I think there's actually a federal court case, 10th Circuit out of Oklahoma. It's Oklahoma Turnpike Authority versus Bruner. It's 259 Federal 3rd 1236. And in that, the court speaks about exactly what you're talking about, the balancing between the interests of the litigants. And that should be something that should be considered by the court when determining whether or not to certify a case as final, is the interests of the litigants which will remain in the underlying action, as opposed to the interests of the litigants which will proceed into the appellate system and have resolution of that issue. In this case, I would argue that due to the location that the parties were at the trial, as to the trial date, that undoubtedly the interests were to proceed forward, and I would suggest that that would be the best interest for this case as of this date, is for the action ultimately to be sent back down to the district court, tried, and then have one appeal, as opposed to multiple piecemeal appeals where the Court of Appeals and this court will have to familiarize themselves with the facts on multiple bases. If there's no further questions, I'll yield.
Any more questions? Thank you, counsel.
Thank you.
I will first note that there are two defendants that did not contest, Darren Othick and Windsor Place, whose counsel is here. And you can assume that they would think this was proper, that they wanted this issue resolved now rather than going to trial and then going back and being subjected to multiple issues. I will note, Beatty's counsel said that they had a remaining cross claim. Not in this case. The judge severed that and gave them a new case number. So that stands apart. In fact, they may have already settled that aspect. So as to all the claims against Alice Beatty and Windsor Place, those are disposed of. And so this case isn't any different than the Martell case, which comparative fault, it makes perfect sense to, and this case with Windsor and this statute and this caretaker policy is a very significant issue playing out in Kansas. There's another wrongful death case that's being played out with this same issue. And they took the same ruling of Judge Fairchild and presented to that judge, and Windsor Place got dismissed out of that. So there are a lot of issues that are setting up that need to be decided now. I don't know what to say to counsel for Ms. O'Brien, because the judge did what we all talked about doing, which is there's no reason to go to trial if you certified this for finality and let the Court of Appeals. It would be counterintuitive to certify it and then just go ahead and do the very thing, the evil you're trying to avoid. So that's played out. There's never been a motion now in this final, 2 years by anyone to say, hey, judge, come on, let's have a trial. They've not done that. So the idea that they really, really want a trial, but they've never said one word to the judge about getting a trial date, should say to this court what's going on. The real issue before the court is jurisdiction. The Court of Appeals has a wrong rule about its jurisdiction, and that's really the only issue here. But the appeal should not have been dismissed. There is no requirement for judges to sua sponte make a certification order.
So you're asking us to find that the Court of Appeals had jurisdiction?
I am,
And then
Judge.
we'll send the case back to the Court of Appeals.
Yes.
You will argue, and if you either side who does not prevail then will file a petition for review. Let me just understand this. We would either grant or not grant that. We could grant it. Perhaps 10 years was not a proper estimate as to when this would ultimately get decided. We're talking about a great deal of time. And wasn't that the concern of the district court to begin with? Is efficiency? Part of the calculus anyway was efficiency.
Yes, I mean, this was the counsel said it was pages and pages of summary judgment ruling. We had litigated this for quite a while. So the judge put a lot of work into this. And so this was a pivotal issue. So yes, and in the show cause order from the Court of Appeals, they simply came up with the rule, we don't recognize
I'm just trying to understand the procedural posture here. We're well into this.
Yes.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel. We thank all of you for your arguments this morning and this afternoon, and the court will take this matter under advisement. That concludes